In majority decision in the case filed by a former member of parliament, Micheal Kabaziguluka, Constitutional Court judges agreed that court-martial is not an independent and impartial court to try civilians since they are not to subject military law. Thursday morning, all parties in this matter appeared before the panel of the 7 justices of Supreme Court led by Chief Justice Alfonso Winyidolo to kick off with the hearing of the petition. In court, Honorable Micheal Kabaziguluka was represented by Counsel Medad Lubega Segona, Caleb Alaka, and the Attorney General for the defense.
You can't walk to a court and say, I don't think that court is going to be impartial. Even in our ordinary courts, that's not allowed. If you want to say the court is not going to be impartial, you must come with evidence.
It is the duty of this Honorable Court to defend the Constitution, because this is the instruction of the people under Article 126. And this is the last standing institution.
Before court, Micheal Kabaziguluka's legal team asked court to uphold the decision made by the Constitutional Court, citing that court-martial is just a disciplinary committee which is meant to discipline only UPDF soldiers, not civilians.
Parliament shall make laws regulating the Uganda People's Defence Forces, and in particular, I underline the words, in particular providing for A, the organs and structures of the Uganda People's Defence Forces, B, recruitment, appointment, promotion, discipline, and removal of the members of the UPDF.
The Constitution should never be read as one paragraph. You need to read all of them. So when you read Article 220 and you read Article 79, you'll get the import of what Parliament does to make laws for the peace and security of this country and the development of the country.
Kabaziguluka's lawyers also cited a lack of independence and impartiality by the members who preside over the court-martial to try civilians.
But the problem we're having in that court is when now Parliament, in its own wisdom, decided to include all other provisions of the Penal Code and other laws which this court should pretend over.
Otherwise, if you allow that to happen, you're leaving them with all the powers. All they need to do is to allege.
They also disagree with the UPDF article, which gives court-martial powers to try civilians. However, this was objected to by the Attorney General.
And it is very clear, my lord, there is no parallel legislature in the country. There is no parallel executive. There can be no parallel court. The best that the UPDF could establish is a disciplinary tribunal.
Even for disciplinary bodies, even in our offices, even in administrative bodies in our offices, those disciplinary tribunals, even employment tribunals, must be impartial, they must be fair, and they must do these things fairly to all the people. What about the soldiers?
Accordingly, Kabaziguluka asked court to uphold the Constitutional Court decision, but this was objected to by the Attorney General, who prayed to court to dismiss this application with costs. After listening to both submissions, Supreme Court justices indicated to both parties that the judgment in this matter will be on notice. Deborah Namamonde, UBC News.